At the bottom, several generalizations can be made regarding patterns surrounding bullying behavior in teachers. And the bullying behavior often involves the public humiliation of targets. And I know, once again, there's going to be disagreement with me on this because there's a fine line between what is discipline, what is class management, and in the area of IEPs, in the areas of behavior plans, please keep this and please take this into consideration. I understand the public education system is fairly one size fits all in its approach. I get that. It's also a community activity. I wouldn't recommend you do it. Did you do it? Did it work?
Yeah, it's good.
Okay. But one thing that you also have to keep in mind when you're talking about a kid with a 504 plan or a kid with an IEP, these are individualized. And if they're individualized, you've got to take that into consideration. And there are a lot of kids out there that do not like public humiliation. It's part of their behavior. They like to be disciplined in private, away from their peers. They don't like big spotlights put on them. So guess where I have stupid complaints? Red light, green light. You know, move your sticker. Move the thing. Get up there and show everybody that you're a bad kid and move your sticker. I mean, how many schools now are using red light, green light and moving your whatever? Your clip.
Yeah, I learned about this yesterday, and we didn't do it on the middle school, high school level, and I said I really think this needs to be a practice that goes away.
No,
I was in an MCS training about and this.
Yeah, well, I completely agree. I mean, look, I'm a child of the 70s, all right? You know, I'm aging myself, but we did not have red light, green light. We didn't have anything other than, James, be quiet. And there was always a little bit of tolerable noise in all the classes. It's just how public education worked back then. I had no anxiety. The only thing I was anxious about was whether I was going to get third-degree burns going down the metal slide and whether I was going to land on my tush on the hard asphalt or whether I was going to get clipped by the metal hanging off of the merry-go-round, you know. Those were my concerns. It's like the most barbaric equipment in the 70s and 80s that we all got to play on. But the difference is that in the environment of public education today, we have a spike in the number of kids reporting anxiety, reporting stress, intentions of suicide. All those things are increasing. And you sit there and you go, well, what's changed? It's not the family. It's the environment where they spend the majority of their day. And you sit there and you go, well, what's changed? Well, what's changed are the requirements. Now we have high stakes testing. That doesn't mean anything to the students at all. It's just a report card for the school. I do not agree with that. I think that there is a better way to monitor our public education system instead of encouraging our public education system to run the gauntlet of skirting public scrutiny. And so anytime that you have an out, somebody's going to find it. Remember what I said about mission creep. Guys, you know, those geniuses in the federal government that love to track people, you know, like we're all show animals, you know, what's your race? You know, what gender are you? Or which of a million? I mean, you sit there and we're not supposed to look at each other like that, but the federal government tracks everybody like that. I understand why they do it. There's always good intent with all the evil that's out there. I'm not one of those that believe in that. So for our high stakes testing, what are we doing? It didn't take long for our public schools to figure out that if we just gerrymander, we can sit there and cleanse our schools of the subgroups that are pulling our scores down. And what are the 4 subgroups that we track for high stakes testing? I know you know, you're a principal. You have to know.
Black, white, your free reduced lunch population,
Uh-huh.
your special ed kids,
Okay.
your main subgroups.
Not white and not Asian. You missed one. Hispanics.
Hispanic.
Okay.
Well, we compare everything.
Well, I know we compare, but we compare to, in fact, and I know that nobody wants to admit this, but actually the most discriminated group in our society are Asians. Do you know why? Because they ruin the curb for the rest of us in college and in schools. But because of that, they are frequently left out and left aside because the expectation, it's like the example I gave a parent the other day. Well, we just started a case down in South Alabama. Kid's a senior. He's on an essentials pathway, which is the occupational diploma. Parent had no idea. She just thought there was one diploma. African-American boy. He's been in a self-contained environment, no behaviors, and they have him tagged as intellectually disabled. And immediately I said, have you ruled out autism? And she goes, autism? I never heard of it. Well, I never considered it. And I said, I want us to look at autism. Now, why would I say that? Well, he had all the markers. The language markers, he had all these issues. Ken met him. Classic Asperger's high-functioning autism. And I could see it looking at the paper. The school never looked at it. Now, why didn't they look at it? Majority of the people the kid interacted with were African-American, administrators, teachers, all that. But what is my difficulty with African-American boys? Having them ever looked at and considered for autism. Why? Because of the stigma associated with any kind of behaviors. And then the first track is to look at intellectual disability. When that just wasn't the case here because there were so many different markers. But I told the parent, I said that if your child was white, if your child was Asian American, everybody would be scrambling all over themselves trying to figure out what was wrong with your child. And they wouldn't tag him with intellectual disability. They would look at the other markers and not ignore them. So these things are very, very real. But we have to always be expanding our perspectives that things in our society aren't necessarily racist as much as they are lazy, intellectually, and just ignorance. And, just continuing with stigmas that, quite frankly, we need to get rid of. But with the high-stakes testing, we've encouraged abuse because we do track the subgroups. We track the subgroups because we have historical discrimination that we're trying to correct. So there's a justification there. I understand it. But what do the schools do to get around the subgroups? They gerrymander their boundaries. There's a school system here, we'll just call it Blefferson County. I'm making these names up, guys, it's not real. But they have a hub and spoke system. And what the hub and spoke system is that they create a school which just by absolute accident is also where they have a high African American population or high Hispanic and high poor population. Well, what's the only other subgroup that happens to exist outside of all of those demographics? Special education. So where do you put all your special education programs like your behavior units and your specialized programs? Well, you stick them in your other subgroup schools. You already know they're going to fail. The high stakes testing. Bloover does that. They have their two schools and then they gerrymander and they'll fill all the apartments in and that's the one that they all go to. Now, why is that? Well, because No Child Left Behind started that nonsense, and it's gone on for so long that now our real estate and our entire capitalistic market hinges upon that stupid high-stakes test. Because why does anybody want to move to Oak Mountain? Well, they're an A+ rated school according to high-stakes testing. And why don't they want to move over into Avondale? Geez, I wonder why. And so there's a lot of confusion in our society to where people are misinterpreting the root cause, and people go, oh, we're taking backward steps in civil rights. This stuff isn't racial or ethnic as much as it is about money. And as much as it is about real estate prices connected to these stinking high-stakes testing, that if we got rid of it, then you would see schools starting to back off of this crazy way that they draw these boundaries. Bluntsville does that. Same thing up there where you guys live. They gerrymander their boundaries. And they have protective barriers on their schools that pass and their schools that fail. And they've given up on the ones that fail. And then you add the component of union rules that we're all, you know, what's the negative to that? Well, they can't get rid of their bad teachers without a big pain in the butt to do it. So what do? They just don't invite them to come back to their school. So what ends up happening is that some of our best teachers in the entire state of Alabama are concentrated in Homewood, in Oak Mountain. I can sit there and tell you where some of our best teachers are. And I always joke with one of the directors, it's not really a joke, it is a joke, but one of the directors of one of my favorite counties, well actually one of the assistant superintendents, I told her that I'm going to wear a t-shirt to our future meetings that just has hashtag Vincent Matters, you know, because of what I consider a resource disparity along with, you know, teacher quality. You know, but so what ends up happening is, it's just like those toys that you have, you know, with the balls, and they're different shapes all the way down. You know, what ends up falling through the very bottom when it comes to teacher quality are kids that are in the most need are at these schools that, due to high stakes testing and some of the manipulation artificially done to skirt that process in concentrating our subgroups, is having a devastating effect, because that's also where you don't have the highest quality teachers primarily. They had a big lawsuit in California about that, and the parents won. Because that's what they were doing. They were trash-trotting the worst teachers over to the most high-need areas. And the parents made a discrimination claim. It was a class suit, and they won. Now, unfortunately, because union members have property rights in their jobs, I don't think it went anywhere after that, because of the mighty union, you know. Some of these things need to change, but that's one of the components. Also, there's typically a high degree of agreement among the students and other teachers inside of the school on who the problem teachers are. It's just that the administrators aren't paying attention. Or maybe they are paying attention, but then they're thinking, what a pain. Or they're thinking, well, I don't want to be under the microscope of administration above me. You know, so nothing is done. But this is where I'm going with all of this. In the middle section, it says, almost without exception, offending teachers mask their mistreatment of students as part of a legitimate role function, using rhetoric of motivation or discipline to justify their actions. We already talked about that. That's important. School officials have a duty of care to protect students. Their failure to act despite notification of a problem enhances liability. But schools can and should reduce bullying by teachers and staff members. Recognizing this truth and being willing to take action are difficult but necessary first steps. You do that, you reduce bullying inside your school. I promise you. These kids are following the example set by their government. See, I'm not one of these people being libertarian-minded that believe that more government is needed. I believe that that's part of our problem in our society. You know, frankly, what I call it is it's organized anarchy. It's tyrannical anarchy, if you want to, because every level of government is sort of acting as its own function. And in our society, that's true. But we have really, really bad leaders right now. And I'm talking across the board. The example that is being set for the citizens is horrible, but yet we vote these people in. And I'm talking about local level. I'm not talking, I'm not pointing at any one person. We have a systemic problem. In fact, I think we have a systemic problem in all of our institutions. Religion, clubs, it doesn't matter. We have bad examples to where people are bad leaders. Bad leaders produce tyrannical results, misery, despondent and unengaged populace. And we see that. I mean, that's part of the reason, I'll go ahead and say it. I mean, it's part of the reason that never mind. I'll keep that. See, there you go. Something just told me to keep my mouth shut. All right. So how do you fix this? Well, you write or adjust bullying policies to explicitly address the conduct of both students and staff. That's what irritates me about the state of Alabama. In fact, we're going to jump over to the next. And this is Alabama's bullying policy. It's the Jamari Terrell Williams Student Bullying Prevention Act. How many of you knew that we had a Student Bullying Protection Act? Okay, we do. Now, does it have anything substantive in it about teachers as bullies or teachers as abusers? No. In fact, our wonderful legislature went to the next degree to specifically exclude teachers from it. This does not apply to, adults or staff members. And guys, what hypocrisy. I don't think that's in there. But what I am going to do is some of this stuff that's just on the internet, that's where I got it, from the internet, from the state. So what I'm saying is I'm going to provide a link to where you guys, because the other stuff that I have on here, I'm going to make available for you guys to go in and print it. Like some of the stuff that I'm going to be talking about as far as IEPs evaluations is just mastering the maze, and I cannibalized it into and condensed it. But it would, my condensed version, quite frankly, is better than what the state puts out there in the big nonsense. You got to chunk this material. And what I like about Mastering Mace currently is that they have broken it into 5 parts now, which I think is easier for staff to digest. But this is the Bullying Act. And like I said, it does not contain any reference whatsoever to when it is the staff abusing. All right. Now, this right here is a Dear Colleague letter from OCR, Office of Civil Rights, okay? It's from 2013. First paragraph, that is in your handout. Although a significant portion of the complaints filed with OCR in recent years have included retaliation claims, OCR has never before issued public guidance on this important subject. So the purpose of this letter is to remind school districts, post-secondary institutions, and other recipients and that's recipients of federal funds, okay? That retaliation is also a violation of federal law. Okay, so how is it a violation of federal law? Discriminatory practices are often only raised and remedied when students, parents, teachers, coaches, and others can report such practices to school administrators without the fear of retaliation. Individuals should be commended when they raise concerns about compliance with federal civil rights laws and not being punished to do so. So this is one where a lot of educators don't know that they're protected. Coaches are protected. Anybody who sees that the school is not functioning the way it needs to function, parents, advocates, every one of them are protected under this colleague letter. And if you look at the bottom, under Title VI of the Civil Rights Act, Title IX, under the Age Discrimination Act, under 504, under Boy Scouts of America Equal Access Act, every one of these have provisions in there that protect teachers, coaches, other employees of schools, advocates, and parents on being able to remedy and call out those violations, and they're free from retaliation. Okay, so just keep that in mind. And this is something that a lot of schools and a lot of employees do not understand that is out there, is this OCR letter. Okay, this is also in your packet. And this is from the American Bar Association letter. It's an article about retaliation. And the person who wrote it is a managing attorney at a law office that does disability rights. So she knows what she's talking about, Rosa. Retaliation is a harmful act against a person that is made in response to the person's grievance or participation in an activity that is protected by law. Anti-retaliation provisions in the law are generally tied to constitutional or statutory rights. Constitutional rights. You sit there and you go, well, how does constitutional rights have to... Well, very easy. The Portland case that we're about to discuss real quick, that was a violation of that teacher's constitutional rights to free speech because they were trying to limit, they were trying to muzzle, they were trying to silence her pointing out what was going on inside the school. And like I said, one of the assistant superintendents and the principal both held individually liable under Section 1983, $50,000 each. And then the school system had to pay her a cool mill because they terminated her, defamed her, ruined her, reputation, all because she was pointing out the lack of services, the lack of equipment, the lack of space for her students. And so it was a protected activity under the Constitution for her, but then also a protected activity under 504 and under IDEA. So, retaliatory action is defined broadly. Remember, I said that earlier. But the one thing, the parent participation in decision-making process regarding a child's educational program is a significant procedural right under the IDEA. Significant procedural right. They are 50% of the decision-making process under IDEA. Now you sit there and you go, well, it's not a majority vote ever on an IEP team. It is consensus. And because it's a consensus standard, the parent is 50% of that team. And so if consensus is not reached and the parent is not in agreement, it doesn't matter how many people are on the school side, consensus has not been reached. And what happens when consensus is not reached on an IEP team? Do you guys know? Well, I know you know. What ends up happening if consensus is not reached in an IEP team? The parent can ask, or they can file a state complaint. They can file for due process. They can ask for mediation. They can ask for a facilitated IEP meeting. Or better yet, if we have parents knowledgeable enough, and that's what I try to train on, sign the IEP and then sign next to your name, I disagree in whole or part with X, Y, and Z. When they write it down, then whoever the LEA is at the meeting now has notice. Because a few years ago, and it was really irritating to me, this is before you were a director, we got wind that the special ed directors were all up in arms because Galini and all the other parent attorneys were filing complaints, and they didn't even know that these problems existed. If they only would have known, they would have been able to resolve them. And first of all, there is no notice requirement under this law. If the parent wants to file a complaint, they have a right to file a complaint. But what I would always point out, and we actually started adding to our complaints, examples within the body of our complaint where the school did have notice. And where typically they had notice was the teacher and the principal. And depending on the structure, the hierarchy structure within the particular district, that information wasn't going above the principal. The principal knew. Oh yeah, the principal knew. Principal was the LEA. Now, I don't make a big deal about principals being LEAs, but technically, principals are not LEAs. Not unless the special education director knights and blesses and kisses the hand of the principal and bestows her wonderful LEA powers on the principal. I don't make a big deal. There's only one special ed director. The only time that I think it is a big deal is if the parent is asking for something outside of the norm. If the parent is asking for any additional resources, then the principal does not have the authority to do that at the meeting. And if the decision is not made at that meeting, then unfortunately, you guys could be in violation procedurally for not having an LEA at your meeting. Because anytime you have a principal or let's say a special ed teacher that is acting in the capacity of an LEA, anytime you have them open their mouth and say, I have to ask, I can't approve your request because I've got to ask the real person who has control over funding decisions, then guess what? You did not meet the definition of an LEA. I'm talking about the legal definition. Now you sit there and you go, well, that's a procedural violation. And in the world of James Galini, procedural violations are not substantive violations unless that substantive violation injured the child's, unless that procedural violation injured the child's program. Now, we want to follow procedure, absolutely. But there's a lot of times when the I's are not dotted and the T's are not crossed, and I don't make a big deal about that because in our analysis, did it tip over and damage the child's program? No, it did not. And that's where the court draws the line. Now, if you have enough procedural errors that it did damage the child's IEP, they did not make progress, the LRE was wrong or some other aspect, then yes, the procedural violations did tip over and create substantive damage. This is what the court cares about. They don't care about the I's being dotted and the T's being crossed. And I can tell you, for the advocates out there, this is where a lot of advocates get it wrong. They over-focus on the procedure and they don't focus on the substance. And the law doesn't care about it. I'm talking due process. When you get in front of a due process officer or a federal judge, they're going to want to know damage because that's what we as attorneys do. We quantify damage. What was the damage done? Where was the damage? Procedure? Yes, that's more of a state compliance, issue, but you always have to do that analysis. Now, in my example, having a principal as LEA and then having them say, well, I'm going to have to ask, but let's say the principal forgets to ask or doesn't want to ask and just ignores it and stops right there. And it was something reasonable and it was something that if provided or agreed to would have provided the child a FAPE. You see where that procedural error of not having the LEA now tips over into creating a substantive damage. And then the special ed director goes, well, I didn't know about it. Well, your principal did. And believe me, none of these cases that I have filed, somebody within the district was fully aware. It just, the chain of communication was not working. So I never feel bad about filing a complaint. But I can tell you that very rarely, I'm always dealing with special education directors, And very rarely did they create, foster, encourage, or have anything to do with the violation that I'm complaining about. And what sucks is that the people that were the ringleaders and were the offenders are not dragged in there to be excoriated by James Galini and my smart mouth. The director gets to sit there and hear me. And they don't want to, and they didn't do it. But the people that really were the ones that stubbed their toe, and that's where I'm saying that the hierarchy is screwed up, because the people who have to fix the problem didn't create the problem. But the solutions, can be implemented by the director and then filtered down. So that's where when we're talking about the parent participation, the functions of an LEA and how that works, having that free flow of communication, making sure that your channels are cross-communicating, like your role, her role, because we see problems in that area as well. The principals especially need to communicate with administrative over 504 RTI and special education. And I'm talking about free flow, constant. That is your huge ounce of prevention in problems on the individual school level. Because of how the hierarchy works, you're going to see things on your level, on your school level as a principal, that administration isn't going to see. You're going to see things with employees that they can't see. You're going to see things with students and know the students on a level that they don't see. And so much of this information, quite frankly, is more pertinent to principals than it even is to administration, because of how closely you interact with parents, with the students, and also with the teachers that do the day-to-day implementation. So not to offend my administrators, but really the most important cog in the entire system of correct implementation is going to be the school principal. And that's why I wish our state mandated, an intensive competence in these areas, and then have the school develop policies that address not only adult bullying of students, but also the chain of command of how these things will be implemented. The one thing that you got to remember, and I'm not really going to touch on this because it's more for parents and also for employees that want to exercise their right and make a claim for retaliation. This handout sort of provides the litmus test in order to be able to do it. So alleging the violation, to state a prima facie case of retaliation under ADA or Section 504, an individual must show that they engaged in a protected activity, okay, which this is. The second one, suffered an adverse action, meaning I lost my job because I wrote a 15-page thesis to my principal about a lack of equipment and a lack of materials, and then they turned around and fired me by systematically giving me bad marks for a school year and then not renewing my contract when my years prior to that I had stellar marks. It's very easy in situations like that, and I just started one up just like that where I represented a teacher, her child, but see, she was also advocating for students inside of her school. And they are absolutely attacking her to the point where she probably is not going to be renewed at the end of this school year because they refused to sign her license. They moved her from 4th grade to 1st grade. She doesn't know how to teach kids to read because that's not their job in 4th grade. So they're doing things to purposely set her up to give her bad reviews in order to fire her, but she's protected under these laws. So number 1 and 2 are covered. The third one, there was a causal link between the two. Meaning that, am I going to be able to prove that if it wasn't for this, then this would not have happened? And yes, we're going to be able to show that, no problem. That's where a lot of parents screw up. Remember when I showed you the letter from OCR, Office of Civil Rights? Yes, we've seen a spike in retaliation cases, but the problem is that the parents are the ones filing the retaliation cases. And because they're the ones filing the retaliation cases, they are not doing a very good job in tying the causal links together. You know, they're sitting there saying, well, you know, I wrote some emails and then they put my daughter in ISS. Well, you're saying that, you know, you're going to have to do more than that because a lot of kids go to ISS. So how is that retaliation? I'm not saying it's not, but there needs to be more meat in there to sit there, because what schools end up having is they have an ability to provide an excuse and a pretext. You know, it's got to be a good excuse. That's what pretext is, because once you reach that standard of the assumption of prima facie, then it flips over to the opposite side of saying, well, give me your pretext, give me your excuse. And if it's a reasonable excuse, then, you know, you don't have a case. And that's what OCR is complaining about. We're seeing a spike, but we're not seeing a good job of tying all of these things together. And that's part of my job now, and also my, you know, the group I belong to of COPA is helping advocates and teachers and parents understand how to tie those together in a better and concise manner so that we are more successful in these retaliation claims against the bad apples inside of our education system. That's the only way we're going to stop this systemic bullying. You know, of shutting our advocates down, shutting parents down. I've got a school system east of here that they banned the parent for a year. What did she do? She got into it with the principal in her office where they were both shouting, you know, because her daughter has epilepsy and they left her in a classroom by herself as punishment. And her daughter could have fallen out and had a seizure. You know, and her IEP says that she needs to be monitored constantly. And the parent, emotional, got upset about it. Went in there. Well, what ended up happening? Well, the principal has the benefit of an SRO officer, also has the benefit of her position, and her position is unquestioned. So therefore, she turned around and said, you are banned for a year. You cannot step on my campus. And it's an abuse of our new security measures, because that's masking, oh, I feared, because that's what I feared, you know, this, a bunch of bunk. But see, now what's happening is there's a question now of whether this parent can procedurally participate, whether she's trying to engage in a protected activity and now the principal, and her excuse isn't good enough. You know, you just don't ban a parent for a year without something more substantive than she yelled at me and I'm the queen and therefore you need to respect that position. No, I'm not in your messed up military, okay? I don't recognize the Queen of Hearts, sorry. I'm more of Alice in Wonderland wondering what the hell's going on around here. You know, so that's where I'm saying